Hey everybody, it's Jeff Davis for Advanced Educational Law. I'll be honest with y'all, I saved this presentation as the last one to do. I had already done the next presentation in Serrano, and I personally didn't want to make a slide presentation slash present the information of this case in the ways that I had with the other ones, because I felt like it would just be kind of disrespectful. And if you haven't read this case yet, you'll understand why. So let me just go ahead. I'll hop into it for you. All right. So right now, this case is the Walton versus Alexander. Okay. And this was only at the circuit court in Mississippi. It didn't go any further than that, and I think you'll see why here in just a moment. All right. So back in 1995, this decision was, but the previous actions happened. In 1987, Christopher Walton was sexually assaulted by another student while enrolled at the Mississippi School for the Deaf. We'll call it DEAF from here on out. The assault was reported to school officials, including Dr. Alma Alexander, who will be known as Doctor from here on out, the school superintendent. Doctor reported the incident to the Mississippi Board of Welfare, and the assault was investigated by both DEF and the Department of Welfare in accordance with policy enacted by Doctor. So previously, Dr. Alma Alexander had enacted or established policy within the school that the school and the Department of Welfare would investigate anything like that. It makes me kind of wonder why they led to that, but that's not explored in this case. The school discipline committee then counseled both students and contacted parents about the assault. I don't understand why somebody that was a victim of sexual assault needed to be counseled in the event like they had done something that was regarding their own discipline. But again, it's I wasn't there. But Walton received treatment from the school physician, and both students were suspended for 3 days. The maximum punishment that Dr. believed was allowed according to guidance outlined in Maddie T. versus Holiday. This was an unrelated case, but it was a sexual assault case by itself that they felt that the 3-day punishment was enough. All right, so what happens next is that both students come back to school, and they are both allegedly evaluated for psychological or seen for psychological evaluation. However, Christopher Walton argued that they had not received any of the evaluation and had not been informed on how to protect themselves from future attempts of assault. So both students were placed in separate dorms. All right, so they formerly were in the same dorm, now they're in separate dorms. But then the next year, in 1988, because of budget cuts, both of these students ended up in the same dorm. However, Christopher Walton is allowed to access to separate bathroom facilities. However, his attacker would sexually assault him again that same year. So Joseph Walton, Christopher Walton's father, filed suit on behalf of his son, alleging that Doctor and DEF, so the superintendent of the school, had violated Walton's 14th Amendment due to failure to protect Walton from sexually assaulted by the alleged attacker. So during this case, whenever it got to the district court, Dr. Alexander requested summary judgment for immunity because they were not a state actor, and they felt that they couldn't be held responsible for the actions of a private actor. But the district court denied summary judgment and decided in favor of Walton, and there was supposed to be a payment made towards Walton, and at this time in 1995, Alexander's already retired from her career and everything like that. Okay, so there's no restitution that can be paid at this point, really. But so Alexander, or Doctor, appeals to the Fifth Circuit Court, and the district court, or the circuit court, repealed the district court's decision against summary judgment because they found that she would have received immunity, and that there was no special relationship with Walton. All right, so the special relationship is something that was identified in the Cheney 1988 Supreme Court decision. So remember that the first action happened in 1987. All right, so the issue. The 14th Amendment says no state shall deprive any person of life, liberty, or property without due process of law. However, or process of law. I'll go ahead and take care of that. All right. However, nothing in the amendment requires the state or officials to protect those guaranteed from the actions of private actors. State or officials can be determined liable if a special relationship is established, and that was outlined in the Cheney 1988 decision. The existence of a previous sexual assault could reasonably justify Walton and Doctor as a special relationship. However, the first attack happened in 1987 prior to Cheney becoming constitutional law, as Doctor provided reasonable safeguards against future attacks prior to Cheney. The Fifth Circuit Court ruled Doctor should have received immunity. So the Cheney decision put into application a three-pronged test. Okay, so the decision, Fifth Court sided with the appellant, Doctor, and entitled immunity, and should have received summary judgment, which would have meant that they would not have the case couldn't go any further. So, opinion of the court is that they should have received summary judgment in the district court. A special relationship did not exist. Court also determined that Walton forfeited portions of their autonomy upon enrollment at DEF, as Doctor was entitled to immunity by actions during 1987's attack. The Cheney had not been decided at this point, and Circuit Court reversed the district court's decision to deny summary judgment. The Circuit Court sent the case back to the district court where no verbal arguments would be heard and only a case briefing would be provided to the judge for decision. So they couldn't retry the trial because that's how the appeals process happens. All right, and then the dissenting opinion. It wasn't necessarily a dissenting opinion. However, the Circuit Court Judge Garwood agreed that with the reversal, but could not join in on the majority opinion, as he believed that Doctor had not violated any constitutional right to safety. They also did not believe there was any need to determine the existence of a special relationship, as Walton had not been taken in custody against his free will or restrained from personal liberties to protect themselves. Garwood also said that the Mississippi compulsory attendance law requires students no less than 13 to attend any school. As Walton was 15 at the time of the first attack and 16 at the time of the second attack, they were not legally bound to school attendance, and Walton's parents would have should have removed them from the school. Okay, move that to should. Okay, and then concurring opinions, none. The Fifth Circuit reversed the district decision. I left the comment section empty because obviously y'all are going to have to come up with your own comments about this decision. But ultimately, here's what it comes down to. A child was sexually assaulted. Now, the child may have been 15. However, not under saying that you are not aware of how to protect yourself against future sexual assaults, I'm not necessarily buying it. I think that there is probably more to it. But I personally feel that upon the first assault, the parents should have taken the student out. And it may be okay that the school was established for special needs students, the deaf. However, would you prefer your child to go to a school where they could potentially become assaulted again? Or would you want them to be taken care of? All right, that's basic Maslow's hierarchy of needs. But then also, why was a sexual assault only 3 days suspension at the school level? I felt like this was criminal, and even though they may have been minors, you can still process legalities and criminal actions against minors, and that's that the alleged attacker should not have been in that school for there to be a second chance for that to happen. Now, what would I normally think about this? I don't necessarily think it was a sexual assault, but I would consider at the time a 15-year-old not knowing how to protect himself against a sexual assault could potentially have been a closeted homosexual relationship that was probably witnessed by somebody on both occasions, and that student just cried wolf. But let me know what y'all think about it, and let's answer the subsequent questions from Caps. Thank you for your time. Again, this is the Walton v. Alexander case. Thank you.